So I'm going to skip through some of these slides fairly quickly because, I really don't care to talk about myself much. In short, I'm an attorney. I've been doing disability since 2010 and worked at both Social Security and as an advocate, as a manager, as a trainer. And I'm now the Senior Director of Disability Benefit Services. Just a snapshot about our program, and that's really not what we're here to talk about. So in short, though, if you need help understanding and applying for disability benefits, we have a webinar series, we have consultation, we also have direct representation. Our general program is a fee agreement process to kind of keep it funded, but we also have contracts variously with like RMHS, UC Health, Jefferson County, Denver, and when possible, we try to use those so we can provide free services. All right, into our topic, all that out of the way. We're going to start with basics of Social Security disability programs, SSI and SSDI. We'll then kind of get into the differences between children and adult and how Social Security handles those. We'll talk a little bit about the application process and how I would recommend that you apply if you're applying on your own. And then we're going to talk about work. We'll end with some talk on that and questions and answers, of course. But speaking of Q&A, generally speaking, if you want to ask your question verbally, I'd ask that you try to hold that until the end. And maybe, Kristen, if you can type that into chat too for those who end up joining later, although they probably won't see the chat message if they join later. So, all right, either way, if you can hold verbal questions to the end just so that we can keep moving. However, if you are able to type into chat, I'm happy to see questions roll in as I get going. And oftentimes I can glance at those, and if it's an easy answer, I'll try to address it. But I can kind of keep that going with the flow. So I'm encourage questions to be typed in. And even then, if it has to go to the very end and we get to questions, they're already saved for you. So you don't have to worry about remembering your question. All right. Supplemental security income and Social Security disability insurance. Social Security offers these two disability programs. Amongst SSDI, there are several sub-programs, you could call them. We'll get into some of those a little bit later. But generally speaking, Title II, Title 16, that's your SSDI, it's Title II. Title 16 is your SSI program. These two programs, non-medically, are very different. They have very different purposes. And because of those different purposes, that is what creates the differences in how Social Security would consider non-medical criteria. Right. And when you're applying for disability, you need to meet not just the medical criteria, but the non-medical as well. Medically speaking, in terms of how your condition affects you, whether that would qualify for Social Security's disability, the two programs are the same. But non-medically, that's the big distinction. Looking at SSI first, which is our supplemental security income, that's an anti-poverty program. It's meant to help individuals with very little to no means pay for their basic living expenses, food and shelter. And because it's meant to help individuals at the state of poverty, they look to see how much assets and resources you have to determine if you need this program, if you have a financial need. For individuals, the asset and resource requirement is less than $2,000. And for couples, it's less than $3,000 in assets and resources. They also treat income differently. So income depends first and foremost whether it's earned income, which they incentivize, and we'll talk about that later, or unearned income, which they don't really have an incentive for, because if you're receiving unearned income that you're not working to make, then they would view that money as something that could be paying for your food and your shelter first. And then SSI will supplement whatever is left over to need to be paid for. So they treat unearned income very harshly in terms of how that affects SSI. And then finally, there are citizenship requirements for SSI. There are some exceptions for permanent residents, for instance, who are asylees or refugees, but that's limited on time. There's an exception for permanent residents, lawful permanent residents who have worked for at least 10 years and earned 40 work credits. And so they've contributed to the taxes. Okay, we'll let them have an exception for SSI. And then there's some exceptions for like grandfathered people that have been grandfathered in because they've been here for so long, or who have served our country and are veterans, or are active duty service members or family members of active duty. So that's SSI initially. We'll contrast that now with SSDI, and it's not anti-poverty, it's insurance, right? Just like health insurance and car insurance and home insurance, you have to pay a premium to get this benefit. Now, that premium isn't literally a check that you write every month. Instead, it's working and paying into the FICA tax. And so then based on your age, when you're alleging that you became disabled, they'll look to see how much you would have had to have paid into FICA over a certain period of time. And if you've met that criteria, then you've purchased enough of this insurance to qualify for SSDI. Now, that FICA tax is the same tax that you're paying into for Social Security retirement. And both disability and retirement are closely linked. If you got disability and you went all the way to full retirement, they'd end up being the same by that point. And so that's really how you're basing how much you earn. But the point of why I'm saying with that is, a younger individual, they might not have paid much into FICA, right? Think a 23-year-old who gets in a car accident. Well, they haven't had much of a work history. They don't need as much of a work history at that age, but still they might only qualify for a few $100s. Disability insurance doesn't care about that in terms of how much you get. It's not an anti-poverty program, but you can potentially also qualify for supplemental security income and receive both benefits, what we would call concurrent benefits. And so you can get SSI and SSDI, and you would get the benefits of both programs when that happens. Both programs would balance out so that you would essentially get SSI plus $20. Now, because the insurance program for SSDI, it's not based on anti-poverty, they don't care how many assets and resources you have. They don't care about your unearned income. There's no reason to worry about that. Earned income, we'll see how that can affect SSDI in a variety of ways, but unearned income has no effect. And finally, you can gain disability insurance either through yourself in your work, potentially through a spouse. You can also, when you're working, you can provide it to a former spouse, or you can also receive the disability insurance through a parent if you've become disabled by a certain age. And we'll talk about that later, and we call that specifically disabled adult child benefits. Now, just a few other differences to wrap up before we get to those actually. SSI, the benefit amount you get. It's an anti-poverty program, purpose to pay for food and shelter, so they cap the amount that you receive, and the amount's capped at $914 per month in 2023. You can receive less than the $914. And the biggest way you can receive less besides work is your living arrangement. And so living arrangement can affect your benefit amount, or it can even affect your eligibility if you're in a state institution. There's a few different ways living arrangement can affect you. The most common is it's a 1/3 reduction for what's called in-kind support and maintenance. But there's another lesser common one for individuals living in assisted care facilities, skilled nursing facilities, et cetera. And those individuals only receive a $30 personal care expense. And then SSI, as most of us know, comes with an automatic qualification for Medicaid. Not as big of a deal in Colorado with Medicaid expansion, but there are still some states that don't have Medicaid expansion, so it's helpful for those states, especially if you move states. In addition, it does get you automatic qualification, the SSI, as a determination of disability for some of those Medicaid waiver programs you might be applying for. SSDI, when we're looking at the benefit amount I already mentioned, there's no specific amount. It's based on how much you've contributed to FICA. Living arrangement, no impact by and large on SSDI, except if you're in a state institution due to a crime. Otherwise, they don't care if you're living on a couch, if you're paying rent, if you're not paying rent, it doesn't matter because it's disability insurance. And finally, it comes with Medicare, although there is a 2-year waiting period from the point that you initially receive eligibility for SSDI. So you do have to wait for the Medicare to start. Before it begins, you can receive Medicaid, right? You can get both Medicaid and Medicare at the same time. And as I mentioned before, if you gain concurrent benefits of both SSI and SSDI, you would be eligible for Medicaid automatically and would be eligible for Medicare after that 2-year waiting period. Those benefits are treated separately as well. So if you're in a living arrangement where you're not paying your fair share of food and shelter, SSI would have the 1/3 reduction, where SSDI would not have any reduction. And so that can change the balance of how much money you receive based on your SSI being reduced. Now, I mentioned you can receive benefits underneath another person's work. And so when we're talking about that, we're talking about disabled adult child benefits. And Jen, I'll get to your question actually very soon. And so let me look at your question in a moment here after I get to it and see if I address it. With disabled adult child benefits, these are when a child is receiving disability insurance through a parent's work record. In order to do this, you need 2 major elements to be satisfied. First and foremost, you have to have proven that your disability began before the age of 22. And I want to emphasize you have to prove that your disability began before 22, not your condition. So there's a difference. When we're talking about Social Security disability, we're talking about, and we'll talk about this definition of disability soon, but they have a specific definition of what it means to be disabled. And that definition differs from the VA, it differs from the ADA, it differs from the school system. It's unique to Social Security, and it tends to be the highest bar test of all the definitions. So when I say proving disability before 22, it's not simply I had autism and therefore obviously it began before 22. It's I had autism and it caused this level of severity that qualifies me for Social Security's definition of disability. And when we're talking about proof, we're often also talking about, evidence. As an attorney, that would be things like medical records, right? Or opinion letters from doctors or teachers, or employers. So it's paperwork by and large that you need to get. Now, because you're proving disability before 22, that also means that you don't have to apply before 22. You just have to prove that your disability began before then. In that sense, I can help someone who's 25 years old, and as long as we prove their disability began before 22, they might potentially qualify for disabled adult child benefits at the point that the second element that I'm going to talk to in a moment is satisfied, which is a parent being disabled, retired, or deceased through Social Security. Now, another final note about that proof before 22, and this is to help emphasize that I encourage parents and individuals to consider applying sooner than later. I've also helped individuals who didn't know about this program back in the day, and now they're at the age of the 30s or 40s or 50s, right? And they have an intellectual disability that I know it was around before 22. Intellectual disabilities in particular, there's clear proof of the severity oftentimes. But do I have documentation that can prove that the disability, not just the condition, the disability existed before 22? And there's a few other pitfalls that can fall between there, such as substantial gainful activity that we'll talk about as well coming up. Lots of things to talk about. So that's element 1, proving disability before 22. The second is that a parent is disabled or retired through Social Security or deceased. Both that can also happen later in life. So I could help an 18-year-old apply for SSI and be awarded SSI. And then later on at the age of 25, let's say mom retires, Social Security looks at mom's record. Maybe she worked for the school system her whole life and paid into para. Okay, mom retired, but you know what? She doesn't qualify for Social Security, so that doesn't change anything. Then at the age of 30, dad retires. Okay, now we have a parent who's retired and he does qualify for Social Security, we'll say, and we have a child who has been disabled prior to the age of 22. Both elements are met. At the age of 30, that child would receive disabled adult child benefits. And speaking of receiving those benefits, if a parent is living under whose record they're receiving the insurance, they can receive 50% of that parent's benefit, or up to 50% of that parent's benefit. If the parent has passed away, they can receive up to 75% of that parent's benefit. And that can be a significant amount more than SSI. Right. And there's lots of other benefits to SSDI, as we just talked about, not having to pay rent necessarily, not having an asset and resource limit, unearned income not affecting this benefit, qualifying for Medicare. So lots of reasons why getting this benefit can be a huge boon to children, adult children. And, just simple calculations over a lifetime, this could mean hundreds of thousands of dollars, easily $500,000 to $1 million more in benefit over their lifetime. So a lot of money can be achieved through this benefit. It can end due to substantial gainful activity, which is working at a certain level, which we'll address later, or marriage. Sharon, your son is autistic, your husband died, so you're his only parent. Which benefit would he qualify for at 18? Potentially both benefits. And I would generally recommend applying for both, because why not? If you qualify for SSI and SSDI, Social Security will balance those books, as we'll see later on when we talk about income, and they'll maximize the benefit. If they only end up qualifying for disabled adult child benefits under the father, great, right? Then you're not really penalized for applying for SSI. If 75% of the father's benefit still allows for some SSI benefit, good thing you applied for both, kind of thing. And SSDI has a 5-month waiting period before it can start. So SSI doesn't. You might receive a few months of SSI before the SSDI kicks in. So I would apply for both. And Social Security will look to see if your husband has worked enough and paid enough into FICA to qualify. It does not reduce, good question, Rebecca. It has no impact on the parent's benefit. Now, what it does potentially impact is there's a family maximum allowance underneath a person's insured benefit. And so let's say that mom retired. She has a family maximum of 150%, roughly speaking. It technically can be a little bit more complicated with death and everything, but generally speaking, 150%. She's going to be receiving 100% of that benefit. So now we have 50% to share. A single individual can receive up to 50%, but let's say the husband is also receiving part of the spouse's benefit and the child is receiving that benefit. Well, they're going to split that benefit then. And it can even offset sometimes, like if the husband receives some benefit but also qualifies for a bit under the wife, then he might not be pulling full 25%, so the child might end up getting a little bit more. It can get fairly complicated. And then, of course, if in my example, the mother dies, then she's not receiving any of her benefit. Now 75% can be split evenly between the spouse and the child. And so both benefits would go up significantly. Either way, no impact on the earner's benefit. Now, I did get the question, or I saw the question about resources for charging your son. Yep. And so here's basically your slide on that. Room and board agreements, which I recommend considering for individuals who are on SSI. And I'm going to break this down into kind of the decision model I would go through if you're looking for simplicity, right? Because separate household is possible, and it's possible for pretty much anyone, but it can get more complicated and you're less likely to have it approved by Social Security. Shared household, if it works, Social Security is going to, they're going to be game for that. They're going to approve it. It doesn't always work. So I start with a shared household and I look to see, well, can we qualify as a shared household? To do that, you take these 11 expenses and you find your average monthly cost for them, or you just take a month and you find out what the heck that is, and you divide it by the number of occupants, including minor children. So let's say we have a 2-parent household with 2 children and one of those children is on SSI. So that's 4 occupants in our home. We're going to add up the food and the mortgage, in which case we won't have rent, or we'll add up rent, food, mortgage insurance, like PMI if you need it, property taxes, heating, fuel, gas, electricity, water, sewage, garbage removal. Add those up, divide by 4. And if that number comes in less than SSI, shared household works. SSI maxes at 914, as I said. So if that number comes in, let's say it's 7,500, because the total of this is roughly $3,000 per month. Great, $750 per month. That's less than SSI's 914. Shared household works wonderful. However, what if it goes over SSI? So let's say you divide by 4 and it equals 1,000. Well, in that case, you can't charge $1,000, right? Social Security will find that you're supplementing that rent every time, because unless they're working, which I think you mentioned in your question, actually, Jen. So if they're working and they can pay $1,000 a month, great. But that also means that if they lose their job, they can't pay that $1,000 a month. And so there's that risk that you would have. How are they going to pay the 1,000? And maybe they have an able account, or there's other kinds of ways of doing it, but they have to be able to pay that 1,000. If they're not able to make it, they're not able to pay it, then Social Security is going to be like, well, then obviously you must be supplementing the rent by giving them a deal and not having them pay the full 1,000. And if that happens, you're providing in-kind support and maintenance, and they're going to reduce the SSI accordingly. So generally speaking, if the rental amount under a shared household is above SSI, I move on to the separate household calculation. Now, this is applied when the disabled person is operating essentially as a separate economic unit. And this is where we get that word household, and it becomes confusing for some individuals, because under a separate household, let's say your son, that 4-parent household, that 4-individual household, and one of the individuals is disabled. Well, let's say that son, who's the disabled individual, they're living in the house with their family, but because they're a separate economic unit, they are a separate household from those other 3 individuals. And so you have to kind of be careful on how you're using your terminology at this point. And even Social Security's materials can become confusing based on how they're using household or how Medicaid's using household. But in this situation, they're a renter. That's what we're trying to establish with a separate household. And because they're a renter, that means they're a separate economic unit. They're a separate household. Much like if I go in and I'm splitting an apartment with a friend, well, I'm a separate household than my friend. Or I might be a separate household than my friend, right? So that's the idea. To decide whether you're a separate household, Social Security is going to review 4 factors: the household organization, and that's things like, are you splitting bills? Is your name appearing on a bill? Or, oftentimes the child's name's not appearing on any bills and not splitting bills. They're not contributing money to split the bills. Okay, great. That's in favor of a separate household. Second factor is rent. What would happen if they stopped paying rent? Would you kick them out? And oftentimes the answer is no, but would you still maybe hold the back pay and say, well, no, but you're going to owe us some money. Still, we're not going to forgive that. Those are factors in whether or not rentally they're a separate household. Meals, do they eat meals separately? Do they store their food separately? Do they have a separate cooking area that they can have? May or may not, but also the question, as I said, you can potentially be a separate household, because could mom and dad store little Billy's food separately in a separate cupboard? Maybe, right? That seems possible. Are there certain foods that little Billy always has? Sure, possibly. Maybe that child has special dietary restrictions or a special diet, and so that they have particular foods. Maybe they have their own food stamps or SNAP benefits that can buy their own food. Maybe they're living in a mother-in-law suite and they can cook their own food. So it depends, right? Sometimes it can change. It just requires a little bit of different household organization in terms of the pantry or whatnot, but that could be argued for as a separate. And access. And this one's the easy one of the easier ones to change if it's not currently a separate household type arrangement. Does the person have restricted access to some parts of the house? You might immediately say no, but then, well, could they? Tell your son or daughter, you're not allowed in mom and dad's room, right? Without permission. You're not allowed in your brother or your sister's room without permission. That's restricting access to part of the household for this individual. And then maybe they have shared communal spaces, but you're still restricting out spots that they're not allowed. Likewise, do they have exclusive access to maybe their own bathroom? Potentially they could. And if that's the case, you can argue for a separate household. Now, the value of going to separate household route is that you can kind of create whatever rent you think is reasonable. Now, generally speaking, it has to be reasonable. So generally speaking, we're talking somewhere between probably around $700 to $900 a month, 7 to 850, 650 to 850, somewhere in that range. I recommend going to Craigslist because it might be as low as 400. I've gone to Craigslist for clients, and I had one person who talked to me, and they talked to a real estate friend, and the friend said, well, this is what rent is going for in this area in terms of renting rooms. And so that's $1,000. I'm like, that seems high. And then I went on Craigslist with them while we were on the computer, and I saw places for like $600, $400, and they're room rentals, right? So if you can find one, well, you can say that your rent is reasonable. So you can look for other places to show and get an idea of how much should we charge. So Jamie, to answer your question really quickly, as we're at a decent switchover spot. If you haven't worked and paid into FICA at all, and mind you, if you worked earlier into paid into FICA, then maybe she can qualify for disabled adult child benefits under you. Otherwise, we're probably looking at just SSI for her. Karina, we'll get to your question soon. Yes, it's going to be just SSI at this point, unless, at least under the age of 18. What age can you state separate household if these things apply? 18 and above is really what you're looking at for separate household, Reiko. Qualify for full SSI amount. Do you automatically qualify for SNAP? I believe so. I'm not as knowledgeable about SNAP. SNAP benefits get offset by SSI, so you wouldn't qualify for a lot of SNAP, but you should automatically qualify for SNAP if you're getting SSI. You should. Social Security has in their application that they can take a SNAP application with them. So I believe you would. I did send a copy of the slides. What if you're a legal guardian? Can you obtain claim separate household? Sure. Anyone can claim a separate household regardless of guardianship. That has more to do with rent questions. All right, we're going to start moving on. I'll come back to questions in a moment, but we got to keep moving at a certain point as well. All right, childhood and adult disability. Let's look at some of those differences. And I don't know about LEAP, Laura, unfortunately. When we're looking at childhood disability, that's disability for children who are under the age of 18. It's only supplemental security income, SSI. Now you can receive benefits under a parent as under age 18, which are under their retirement benefits. Those are called childhood benefits, but they don't require proving disability. So it's not childhood disability because you're not proving disability. So for instance, dad retires through Social Security, child is age 14, that child's automatically going to get a portion of dad's benefit because that child is under the age of 18. Now, because they have not proven disability, come age 18 or 19 if they're still in high school, if they want those benefits to continue under disabled adult child benefits, they have to prove that the individual is disabled now. So they would have to file for disability benefits. Now, in terms of filing for disability benefits, though, as a child, only SSI, supplemental security income, is available. Now, you do have a couple things that I want to note with that. First and foremost, I mentioned SSI is an anti-poverty program, right? They're looking at your assets and resources, but Social Security recognizes that most children don't own their own assets and resources, right? But parents do. And it wouldn't make sense for Social Security to say, well, this child has no assets and resources, so we're going to give them money, even though their parents are millionaires. Parents have plenty of means to provide for the child. So instead, Social Security does what's called parental deeming. They deem a portion of the child's assets and resources a portion of the parent's assets and resources to the child. I could get into kind of the specifics for that, but it's really not too necessary. Suffice to say, if you are a parent, a single parent, and you own more than $4,000 in assets or resources, your child's probably not going to qualify. Likewise, if you're a two-parent household and you own more than $5,000 in assets and resources, the child likely won't qualify. I will mention, though, that when Social Security is looking at assets and resources, I didn't say this earlier, they don't count everything. They do exclude some resources. So they're not going to count, for instance, the home you live in as a resource. They're not going to count money in an ABLE account. They're not going to count special needs or supplemental trusts. They're not going to count one of the vehicles that you own, the more expensive of the vehicles. If you own a second vehicle, they'll count the value of that. And so there are some things that they're not going to count household goods. There's some things that they will set aside and not count as assets or resources, but pretty much everything else they will. They also deem income to the child. And I will just quickly show you. So this and this childhood medical listings are both hyperlinked. So when you get a copy of the slides, you can check this out yourself. Social Security has this nice little chart here. If all the income is earned or all of the income is unearned, you can generally use this as a guide for whether you would qualify based on income. So if there's, let's say, one child applying and no other children in the household, that means there's 0 ineligible children. And we'll say it's a two-parent household, their monthly income has to be $4,695 or less. Or I'm not even sure. Actually, it has to be below. It has to be less than $4,695 per month. If there's 2 children with just one of those children not qualifying or applying for SSI, so one ineligible child, it jumps to $5,152. Right. So you can use this chart as a general guideline on the income deeming rules. It does not apply when there's both earned and unearned income, because Social Security treats unearned income very harshly, you can see. And so you would have to call Social Security, and regardless if it's something close even to these numbers, you would want to call Social Security to find out for sure. And they can do the calculation. Now, when it comes to the medical criteria, which we haven't talked about yet, right? We just said that non-medically, these programs are different. Well, now we're talking about medical criteria, which is the same for both SSI and SSDI, though here for children, we only have SSI. First stop is the medical listings. That's the first stop to say whether or not you're disabled. There's a few other steps before that. This is technically step 3 of the 5-step process. Although for children, it's not 5 steps, it's only 3. But this is step 3. They first look to see, do you meet or equal a listing? I'll show you the adult listings coming up so you can see those. Well, I'll show you these. So they're going to look at these listings real quick. They're divided into different categories. If you drill down into them, you can see the specific requirements to prove that you're disabled, right? And so this is fun late night reading for you. But that's how you can first qualify as a child. If you don't meet those listings, then you can functionally equal the listings, which we call functional equivalence. Now, to functionally equal the listings, Social Security looks at these 6 areas here I have numbered out, and you have to be markedly impaired in at least 2 of those areas or extremely impaired in 1 of them. And they're going to determine that marked limitation or extreme limitation by comparing your functioning to that of like-aged peers. Right. So for children, they divide into 5 age categories, and they look at other children within that similar age range. So they're not comparing a 15-year-old with a 4-year-old, for instance, in terms of functioning. And then finally, what happens when you turn 18? So if you have a child, they're getting disability benefits. When they turn 18, they become an adult. So within 1 year of turning 18, not necessarily when they turn 18, but within 1 year of it, Social Security will initiate an age 18 redetermination, which is essentially a continuing disability review. It's a reevaluation of whether you are still disabled now under the adult criteria, which tends to be a little bit more difficult to meet. The medical listings are often fairly similar between children and adult. There's sometimes some differences, but they're typically fairly similar. But adults don't have that functional equivalence test. And that makes a big difference for some individuals. Looking at the adult criteria, we have both supplemental security income and Social Security disability insurance. you can first apply the month that you turn 18. Now, sometimes I've heard, oh, Social Security told me not to apply until after the child turns 18, or they told me to apply the next month. And those are fine. They're not technically correct, but they're fine. And they're not going to hurt. So what happens here is the month that you turn 18, parental deeming is still applied. And so even if, let's say I have a child, they turn 18 in October, I could apply October 1st. Now, Social Security, because parental deeming applies in October, if I'm applying at 18, chances are I already know parental deeming is preventing an application from going forward. So they're like, well, parental deeming applies, they're not going to qualify. We're going to amend, they're going to change the onset date to November 1st. But they should still accept the application. And that's what's important, because for me, I want a decision as soon as I can get it. And so if I can apply in October, I'm that much closer to a decision than if I wait till November. Financially, in terms of the benefit that the child would receive, there's no difference, right? Either way, they're going to get the same benefit because the application is going to be moved to November 1st. And with SSI, you don't qualify until December 1st then. So, tomato, tomato. I like to apply as soon as I can, but it's fine to wait. And if you're worried that Social Security is going to misprocess the application, that's fine too. Just wait a month. The exception exists, though, for foster care youth. For foster care children, you can apply 180 days before the 18th birthday. The idea behind that, or policy behind that, is upon turning 18, many foster care youth might lose the benefits that they're receiving. It's kind of a cliff. And so by applying up to 6 months prior, they have an opportunity for Social Security to decide if they're disabled so that those benefits don't just suddenly cut off. Only at this age, only the claimant's income, assets, and resources are reviewed. There's no parental deeming. So you might have so there's a lot of people that I work with where child's not eligible under the age of 18 because of parental deeming, and we're planning that application for the age of 18. And planning being the big word, because I do, the more planning I can do with families, the better. Disability case is like an iceberg, I like to say, because the vast majority of that case is done before I even get my hands on it, because that's what treatment has this person gotten in the past. What sources are there for opinion letters that exist? I can't change anything in the past. I can only change what goes going forward, and that's a very small portion ultimately of the case. So the more you can plan for this, the better. Adults have their own medical listing requirements, as I mentioned before. If they don't meet those, there's no functional equivalence. Instead, Social Security takes their functioning and says, can you do past relevant work or any other job in the national economy? That tends to be a pretty high bar test because there are just a ton of different jobs in the national economy of varying physical and mental requirements. And to make matters worse, Social Security has not updated their Dictionary of Occupational Titles since most of the last update was in the 70s, and there was a small update in the 90s. So we're going on 30 years now at best. So the jobs are really old and outdated. And if you can find a peanut sorter job, please let me know, because I don't think that those exist, but clients still get denied for them. So, that makes things even more difficult when you're applying. Very high bar test for adults. One exception, it does exist, though, for adults who are turning 50, 55, and 60 for physical health conditions. That gets progressively easier to prove disability. But generally speaking, adult medical listings is where I first go to see if someone's disabled and try to prove it. Let me pause and catch up on some of the chat questions I've seen. Let's see. So I mentioned the LEAP. I don't really know if you automatically qualify for that with SSI. I think there's a good chance, but I just don't know. Rent when the adult is on the DD waiver, room and board cannot exceed the state room and board rates set yearly. Good to know. If you don't qualify for SSI, but my autism spectrum disorder child would qualify for SSDI. If I don't qualify for SSI, Victoria, I'm not entirely sure what you mean by if I don't qualify for SSI, but my child would qualify for SSDI. If you're talking about disabled adult child benefits, then that only comes into play when a parent is receiving Title II Social Security, so Social Security Disability Insurance or Social Security Retirement. So you would have to qualify for SSDI, not SSI. But I'm not entirely sure what your question is going towards. So if you can just clarify for that, I'd appreciate it. Harvey, minus income, can a child still qualify if they meet all the medical listings? Yeah, I mean, if we're not counting income, and we'll talk about income in a second to clarify that. And they do have to qualify for the non-medical requirements. So when the non-medical requirements are more than income, right? It's the asset resource requirements, or it's the insurance requirements for SSDI. So that would be what I would say, Harvey, is non-medically, that's the biggest thing is that's why, a child's going to be turning 18. And let's say my parental deeming prevents that child from qualifying for SSI right now. Well, I need to make sure at age 18, that child doesn't have $2,000 in assets and resources. Or if they currently do, and I need to move those around, there's a 3-year look back period for SSI. I better move those well before the age of 15 so that 3-year look back period is gone, or I need to transform them into an acceptable form. So taking them, putting them into an ABLE account, putting them into supplemental trust, etc. You can navigate through the link of children very easily, quickly. Oh, I see someone shared it too. If my child doesn't qualify for SSI, they can qualify for SSDI. They can only qualify for SSDI if they meet the non-medical requirements. So the SSI and SSDI, medically speaking, it's the same requirements. So if we're looking at non-medically and they have too many assets and resources, they would have had to have worked, or they would have to qualify off of the insurance of someone else who's working. Adult child has lease, converting room and board. Can you apply for SNAP? Not sure. I don't know about SNAP. Does PTSD see PTSD count as a disability? Sure, it does. So Andrea, let me answer that question more broadly, and then I'm going to start moving on again. I'll get to your question again, Victoria, just because it looks like clarified. It doesn't matter what condition you have. Okay, because I do get these kind of questions sometimes. It's not about the condition with Social Security. It's about the severity of the condition. The only exception to that is non-mosaic Down syndrome. That's the only condition that qualifies for disability because of the diagnosis. Everything else, it doesn't matter your diagnosis. If it's been diagnosed by an acceptable medical source, by a doctor, Social Security will consider it. They're never going to turn you away because, oh, do they recognize CPTSD? No, they'll evaluate it. The question becomes, how severe is this? How is this affecting your functioning? And it doesn't matter how rare the genetic disorder is or anything like that. Now, what that does affect, especially when we're talking about rarity of conditions, is whether or not it has a specific listing within those listings I showed you. If it doesn't, Social Security will just find the closest listing to that condition. So they'll still look at a listing, but they'll have to kind of find the closest one. I'll give you an example, migraines. Migraines don't have a listing, but they will look at certain listings to see if migraines qualify under a disability listing. And they'll also look at step 5 and whether your functioning from migraines will prevent any work. So they'll evaluate it regardless. It's just a question of how. So yeah, and Victoria, that's yes. Now I understand what you're saying. His ASD diagnosis won't qualify him for benefits necessarily. That can meet the medical criteria for SSI or SSDI, but it's not the diagnosis. You have to meet the non-medical criteria and the medical criteria. So non-medically, he would have to either qualify for SSI or SSDI. He would either have to have less than $2,000 in assets and resources to meet SSI's requirements, or he would have to have worked and earned disability insurance, or be filing under someone else's insurance, which is often going to be a parent's. If he meets one of those two programs' non-medical criteria, then they will look at the medical criteria to see if the autism spectrum disorder is severe enough to qualify. But you can't get around the non-medical criteria. You have to pass that criteria first and foremost. All right, I will get back to these other questions, but we have to move along. Okay, just checking my time. Started at 6, we're going to 7:30. All right, we're in good timing here still. So when we're talking about the process of applying for disability benefits, I like to start with just understanding kind of how a bill becomes a law kind of thing. So this is your Schoolhouse Rock version of Social Security, except I'm not going to sing, I'm not going to dance, there's no cartoons, and really it's not that fun. So it's nothing like School of Rock, strike that from your heads, but the idea being this is how your application moves through a system. Your application starts at Social Security. And just like I was clarifying with Victoria, they're going to look and evaluate, do you meet the non-medical criteria for one of the two programs, SSI or SSDI or both? If you meet the non-medical criteria, then they send the case to Disability Determination Services, which is a state agency. And DDS evaluates the medical criteria and the medical qualifications to see how severe is your condition. If it's a child, does it meet the criteria for children? If it's an adult, does it prevent work or meet the medical listing requirements? DDS has several tools in their tool belt to make that decision, right? They might send you to a consultative examination, which is a doctor that the state pays for you to go see and kind of get some sort of extra evaluation. With autism, for instance, it's going to probably be a mental status exam. You can avoid those sometimes if you're already seeing a psychiatrist or a psychologist, and you get that psychiatrist or psychologist to periodically, think every 90 days, do a mental status exam. Conversely, I will have clients where Social Security orders a consultative examination, and let's say my client does have a psychiatrist or psychologist that the child is seeing. In that situation, I call up DDS because I've already talked to the parent about this, and I ask, although I know they're going to grant it, hey, John Doe has seen a psychiatrist. Is all you need a mental status exam? If so, I can have the psychiatrist or do the mental status exam. Would that be fine? They agree to it every time. I haven't had them refuse it yet. And so I get the psychiatrist who knows the child and is probably going to do a better job than the CE, I would biasedly say. We submit that mental status exam by them. There's no need for a consultative exam. If you have that option, take it. Right? It saves you. It's better. It might cost you a little bit more money because it's another visit to that psychiatrist or psychologist, but it's far better because that person knows the child. They can take into account those limitations. They can explain that to Social Security, where a doctor that your child's never seen before, there's all kinds of things that can go wrong with that. So I recommend that myself. I do say psychiatrist or psychologist. So initials wise, it has to be a PhD or a PSYD. Those are your two. MD, nope. DO, nope. PhD, PSYD, that's it. And that's for mental health specifically. Physical health, yes, MD or DO and other kinds of things can pop up. So they can also, they'll consult with a medical expert. They're going to gather your medical records. They're going to request function reports, all kinds of things. After they make their decision, they send the case back to Social Security. And now Social Security is responsible for notifying you of what the decision is. They can also review the case to make sure that it's still correct. And they commonly will review one aspect, which is the non-medical criteria. So a client might file for SSI, qualify for SSI initially, send the case to DDS. When it gets back to Social Security, Social Security needs to make sure that their situation has not changed and they still qualify for SSI. They can also conduct quality reviews on occasion, and they will review even the medical decision that DDS makes, because ultimately this is Social Security's program and DDS is just acting as Social Security's agent. So Social Security is at the beginning and they're at the end of the process. I like to note that, and I should connect that last dot. I like to note the Social Security DDS connection because depending upon where your case is at, if you have an issue you want to resolve, and I'll flip back to the slide real quick, you need to contact that specific agency. So if I'm getting a request for a function report and I need more time to fill out that function report, don't call Social Security. They have nothing to do with the function report. That's a DDS element. That's a medical evidence situation. Call DDS if you need an extension of time, because Social Security, they're not going to communicate with DDS on your behalf. And they might tell you, oh, it's fine, just get it in as soon as possible. But if they don't, then they're not going to tell DDS about this. And I've had a person come to me and we found out later this happened, just as I'm saying, they don't tell DDS. DDS doesn't know you need an extension of time. DDS might deny your case for failure to respond. And then you're like, but I was told I have as much time, I have time to get it in. Well, tough, you contacted the wrong agency. That's going to be the position that Social Security is going to take. So, make sure you're contacting the right agency if you need extensions of time, if you have questions about how to get documents to people, etc. Now, when it comes to filing the application, you can file it in person, which these days means over the phone, unfortunately, or you can file it online. There's good and bad to both. Generally speaking, online is more convenient. You can work at your own pace. You control the information. It doesn't need to be completed in one sitting. You can gather information and before you complete the application if you need to fill things in. Lots of benefits to online. The biggest downside, only SSDI can be filed online currently, and the adult disability report. If you can create a My Social Security account, you can also file the SSA 827 form. You cannot file the SSI application. I've heard for over a decade now that they're going to get the SSI application online. So any day now, right? But when that happens, I'll stop holding my breath. Until then, if you want to file for SSI, you have to do a phone appointment. Now, the nice thing about the phone appointment is it's like the Walmart of appointments. You can do everything you need to there. It's one-stop shopping. The downside of a phone appointment is it can be very stressful. The person might not be very nice. They might be rushed. A lot of similarities to Walmart here. And I'm not bashing Walmart because I've shopped at Walmart many times, but it can be very stressful, right? You can have a lot of people there. You have a limited amount of time that you can do everything. You'd like to say that because you're talking to a person, they can be helpful, but because they might be stressed and everything, they might not be helpful. So phone appointments, not necessarily perfect, but you can do everything over the phone, including verbally signing things. So what do I recommend? I recommend first calling Social Security, especially because I typically recommend people file for both SSI and SSDI, and find out what you get. And even if you know you don't qualify for SSDI, because you can file for the adult disability report online, that's what happens here. Start by calling Social Security, schedule your appointment. Once your appointment is scheduled or you've started that process to apply for SSI, you can go online and do the SSDI application. And more importantly, you can do the adult disability report. When you get to your phone appointment, let them know you've done the adult disability report already online. That saves you time in that phone appointment. So now that 90 minutes is a little less stressful. The examiner, the claim specialist doesn't have to go as fast. They might be a little bit nicer, right? It might result in a better experience overall. And you still get the benefits of the online application of controlling the information, which I really love, and doing things at your own pace. If you do file online, or regardless of what you do, when it comes to submitting stuff for Social Security, document and save everything, right? Keep all your communications. I don't care if it's been 5 years, don't shred that stuff, or save it electronically, right? Scan it in. I've had situations pop up where someone comes to me about some problem that they found out happened 5 years ago, for God knows what reason. So save things, especially that you submit to Social Security DDS. Always keep a copy of that, because Social Security is well known for losing things. And if you need to resend something to Social Security, it's nice if you have a copy ready to go for that. Print your application and receipt when you file online, which this screen is what you would see online when you're finished. And I drawn arrows to the things that you want to click and print. And by print, that might mean print as PDF, so you're saving it to your computer. That's perfectly fine too. After you apply, you're going to get paperwork eventually in the mail, like the function report and the work history report. When you get that, you only have a limited time to respond. So I personally recommend starting those things early and taking notes, kind of getting a jump on it all. DDS might request a consultative examination, as I mentioned before. There are ways to avoid that if you're proactive. And your decision time is getting longer and longer, unfortunately, is the bad news. 10 to 14 months, average of 12 months. You can get cases faster. Cases can be expedited, but it's just your average, it's getting longer and longer, unfortunately. So preparation and organization, I think, are a key to success. Understanding the process, great. Now you know what to prepare for. You can do daily journals. You can get medical opinions. You can create doctor appointments, get updated testing if you need it. Big testing for children, I like to mention. If you got the last testing before the age of 16 and you're filing as an adult, or you want to file later at the age of 18, it's going to need to be updated. IQ reports are valid for life after 16. Violent tests, technically there's no statement on it, but I would still get it updated after the age of 16 as well. You don't necessarily need both. So if there's an intellectual disorder, IQ tests are great. If there's not, go with a Vineland. Or get both if it's both IQ and, say, autism spectrum disorder. Let me try to catch up on some of those questions that I've seen coming in chat. It's been numerous, so I'm going to not be able to go to all of them again. Are grandparents' assets still considered? Because of this, even though he does not live with us. So the answer should be no. First and foremost, when you say grandparent assets, the question comes to, have the grandparents adopted the child? Because otherwise, grandparent assets are irrelevant if you have not adopted that child. Even if you had adopted the child and you're technically parents, which I've seen, if the grandchild is not living with you, there is no parental deeming. So I'm not sure why the grandchild was not qualified. Did not qualify unless there were assets the grandparents held that were in the name of the grandchild, which could be the case in some cases of like a trust, for instance. So without knowing specifics, I can't really get you any further than that, Krista. You could potentially email me. If I have time at the end, I'll explain to you why emailing me isn't going to be great for the next several weeks. But I will hopefully eventually get to your question if you want to email me more specifics. Although it's in the past, so there's not much you can necessarily do about it, but we could do something going forward. Is the only way to prove disability before the age of 22 by applying for SSI? No, you can apply later on after the age of 22 even. There are some situations where individuals don't qualify for SSI because of assets, for instance. And so they don't apply before the age of 22. If you're talking about a delayed application like that, though, the biggest advice I can give you is gather the medical records and gather the school records yourself and save them, because by the point you do apply, you need those. And if you're applying with SSDI, and let's say you're applying for disabled adult child benefits, that does require a parent is disabled, deceased, or retired. So that might happen after the age of 22. But you do need to establish disability before 22, whether that's an application before 22 or an application afterwards that proves a situation before 22. Karina, in terms of chances of a toddler with autism qualifying, I don't know, because it is very individualized when Social Security looks at limitations. So I'm not sure without knowing more. Right, it would have to be something we would assess on a more individual basis. The 3-year-old's limitations or their functioning is going to be compared to other toddlers. And so if his or her functioning is markedly impaired compared to the other toddlers, he could qualify. And just to note, though, you said SSDI. Under the age of 18, only SSI is available. If a parent is disabled, deceased, or retired, and there is a 3-year-old, they're automatically going to get childhood benefits under that parent. It won't be disability benefits, but they get a benefit, essentially equal to disability benefits. At the age of 18, they'll have to apply for disability benefits to keep those going. How would you handle an application for an adult disabled child who splits time 50-50 between divorced parents? If they're an adult, they're their own person. So there's no parental deeming. So it really doesn't matter in terms of the parents being, whether they're divorced, co-guardians, or anything like that. Basically, it's, hey, where do we want the mail to go? That's the biggest question that comes about. Are you guys in agreement to file for disability? And then I'm not mentioning your name because it was a direct message instead of a general message. Are you saying mosaic Down syndrome makes obtaining SSI more difficult to obtain than non-mosaic? Technically, yes, I am. That doesn't mean it's quote unquote difficult, but it's more difficult than non-mosaic. You can still qualify. Oftentimes, mosaic Down syndrome is still very severe, but the condition by itself does not automatically qualify, and non-mosaic Down syndrome does. So mosaic Down syndrome would have to be looked at in terms of its functional impact on the individual. And so I can't guarantee that it would qualify. It would have to be an individualized assessment. One more question. You can contact us, Victoria, and we can look at it and talk to you more individually about that. And if you're talking about we make too much for SSI, so the individual is still a child, you might just have to wait to the age of 18 to file. That might be the out. If they are already 18, it doesn't matter how much the parents make because there's no parental deeming at the age of 18 or above. All right. I have Karina's question coming up next, but we're going to move on to work and see how much question we have for Q&A at the very end. And then it's just cruising on with questions. Work. And I'm going to take a pause for a drink. And at some point, I might even slip in a throat lozenge. And I'm sorry if that there's some clicking and clacking of my teeth with the throat lozenge in there, but we'll see. When we're talking about work, there's two distinct periods we need to talk about. There's before and during an application, and there's after a case has been approved. We're going to start with what happens before and during an application. Here's our definition of disability for Social Security. It's the inability to engage in substantial gainful activity by reason of a medically determined impairment that has lasted expected to last for 12 months. That first part's the key part, though, in terms of work, what we're talking about. Substantial gainful activity. So what is SGA, as it's more often abbreviated? Substantial gainful activity, or SGA, is income that's under a certain level. And it's gross income, although it's gross countable income, I should say, underneath a certain threshold. And for 2023, that's $1,470 per month, or a higher limit if you're blind. And they also consider that you're able to sustain that income for a set period, which we'll talk about actually a little bit later. So I've broken this SGA down into four big things I want to look at, or I would say you should consider. Earned income. It's got to be earned. So for instance, if I'm working, every hour I work, I make whatever, I don't know, $20 an hour, whatever the hourly wage is, that's earned income. Hour work, $20. Hour work, $20. Vacation and sick leave, there's no hourly wage for that. It's not earned income. It's a benefit. So that's unearned income. Substantial gainful activity only looks at earned income. So that's the first thing. Second, it's got to be underneath the threshold, but that threshold itself is modified because it's got to be countable gross income. There are lots of exceptions and reductions to countable income. We'll get into some of those very shortly, but that 1470, as a brief example, I've helped individuals who are making over $4,000 a month on average, but their countable income was brought below substantial gainful activity, of that, well below the 1470, because this was past applications. So it's not necessarily what income you're making, it's what countable income you're making. And that makes a big distinction for many individuals. In the sustained period, we'll talk about very soon. Now, the consequence of making substantial gainful activity is that you can't qualify for disability. Not only that, but you can't really qualify for disability prior to the SGA in some cases. So a quick example, I've been talking a lot about disabled adult child benefits, DAC benefits. As I mentioned, DAC benefits require that you prove disability before the age of 22. If I'm filing for a 25-year-old and that 25-year-old had work at the age of 23, and that work was found to be substantially gainful or substantial gainful activity, we can't establish an onset before 23 because of that SGA, which means we can't prove disabled adult child benefits, right? So SGA can have a significant effect on when your onset of disability is found to begin. And there are situations I've had with clients where I'm helping someone I've helped a client who's in their 50s with an intellectual disability who was sheltered their whole life. Parents didn't understand disability back then. I mean, who the heck talked about disability back then? But the parents also found them jobs. We looked at it and it's like, I know you would qualify for disabled adult child benefits because of the severity of your condition, right? The IQ disorder that you have, you must have qualified back in the day. But because you've worked and you've made a set amount of money, and this happened so long ago, we can't do anything to prove that this work was not substantially gainful. So even though there's numerous reductions that can normally be applied to work, sometimes you just can't because it's too old, it's too remote, or there's just no evidence. And that prevented an onset date prior to the age of 22. So knowing this can be a huge boon. All right, rules that affect countable income. Now, again, we're talking about the period of time before or during a disability application. We're not talking about after an application's been approved yet. Before or during application, we have only about 5 different rules we can apply. Subsidies and special conditions. This is a situation where Social Security is looking for the value of the work. They're considering value purely from a pay rate standpoint. So I'll give you a quick example. Let's say a client has 4 job tasks that they can do, and the other tasks are limited, whether it's physically or mentally, and they just can't do the other tasks. But in total, if they, a typical worker in their position who's paid the same amount as them, maybe instead of doing just those 4 tasks, they're doing 8 to 10 tasks. Well, you're still paying this person who can do 4 tasks, or you might still be paying this person who's only doing 4 tasks the same amount as the other workers doing 8 to 10. As a result, you're subsidizing that person's pay, right? They just don't have the same value as a worker that can do more. Or conversely, you have to have other people work and pick up those job tasks that this person cannot do. And, as I said, we're talking about strictly the monetary value that Social Security is assessing here, because obviously employers might look at the same individual and say, well, they're a huge value to us because they're a joy to work with. They bring up morale of our other coworkers. They increase our client, our clients love them, and there can all be kinds of other values that the employer sees. And that's why they offer these kind of accommodations. But from a Social Security perspective, they might say that that individual is getting a 50% subsidy. If that was the situation and this person made $2,000 a month, a 50% subsidy would reduce their countable income to $1,000. $1,000 is less than substantial gainful activity. They could qualify for disability benefits. So subsidy special conditions, that's one of the countable income reduction rules. Impairment related expenses can be another big one. Those are out-of-pocket expenses that you're paying that help you work and are related to your conditions. Blind work expenses are basically the same thing, except they're expenses associated with being blind. Self-employment, you have unincurred business expenses, and unsuccessful work attempt. This is that situation of sustainability I mentioned, where if you're working for less than 6 months, or you're making I don't want to use the word substantial gainful activity because it's technically not. Let's say you're making above that 1470 in gross income. Countable income is above 1470, but that is sustained for less than a 6-month period, and you stop working that job or you reduce your income underneath the 1470 because of your condition. When that situation is present, Social Security can find that an unsuccessful work attempt, which means that entire period of work that's less than 6 months is not counted as substantially gainful. Even though the income appeared above the substantial gainful activity limit, because of the unsuccessful work attempt rule, it's not. So you can see many situations where work it's being considered against SGA. You might think, well, why bother, right? That's a lot of work to prove that something is not substantially gainful. Potentially, I have to go through these work rules. That's a kind of a pain in the rear to do. Why do I even, why do I care, right? Why is it worth my time? Well, that's why I like to end with this slide in terms of this employment and why we encourage employment. Because first and foremost, it might not hurt your case at all. Yeah, you have to jump through some hoops to prove that your accountable income is less, but Social Security is going to evaluate whether you can work regardless. And in fact, they're allowing you to work and make income and still be found disabled. So if you're choosing not to do that, you're turning down money, right? You're turning down a certain thing. And the benefits that you're turning down is more than just financial, which is the obvious, right? Financial stability and independence. Studies have shown work has increased self-esteem, which can have a corresponding effect to increases, or I should say decreases, in fatigue, pain, depression, and anxiety. So working at a manageable level, I'm not saying working 40 hours, but working at what makes a person feel good can improve their health. It can increase your connection to your community. It can increase your credibility before Social Security. It provides you additional evidence and documentation to prove your disability with Social Security, which is huge from my standpoint, because proof, as I mentioned before, is a documentation situation. You need documentation. And it can also be shown to decrease the use and dependence on drugs and alcohol, which can both be good for the person and for the case. So there's lots of benefits to working and why you should still consider it. Now, if you've already been approved for benefits, work might affect your benefit. So how does it do so? This next slide is a bit of a pain because it's a lot of math. So if you look at numbers and your mind goes blank, that's okay. Let me help you out. Close your eyes and let me give you the gist of this. You're going to make more income working and on disability than just on disability. That's the big takeaway from this slide. This slide gives you an example of 3 of SSI's basic work incentives that they always apply. General income exclusion, earned income exclusion, and the 2-for-1 exclusion. Every $2 you make reduces SSI by $1. Our example here is someone who had earned income of $565 and SSDI, or unearned income, of $420. Combined income would be $985. How would that reduce a person's benefits? Well, the earned income and the unearned income are treated differently. And so you can see on the right side how these are treated. The general income, for instance, after a $20 income exclusion, that's it. That's all that reduces the unearned income. The earned income, though, has both a $65 earned income exclusion and then the 2-for-1 exclusion applied to it. And so in total, this would reduce your SSI by $750. That still leaves $264 of SSI benefits. Total income then would be $1,249, which is more than the $914 that you would get just on SSI. And if we took that SSDI income and instead we said that was just earned income, and it was $985 of earned income, your total income would increase to roughly $1,549, because instead you still have those that $20 and $65 earned income exclusion, but now your $900 would be divided in 2, leaving $450, and then it would be a $450 reduction instead of a $750 reduction, so you'd get $300 more. So you can see earned income, it's incentivized, you're going to make more. That's a big takeaway of this slide. And besides those 3 basic work incentives, there's so many more, right? Just look at this slide. I mean, student earned income exclusions, subsidies and special conditions, which I've already talked about, parent-related work expenses. Section 1619A and B is huge. That's, in essence, that's saying that even if your earned income is above substantial gainful activity, You can still get SSI and 1619B, even if your earned income is so much that you get $0 in SSI benefit. As long as you're under an even higher threshold for Medicaid, you're still considered SSI eligible and you still automatically qualify for Medicaid under SSI. So those two are huge because we're talking about Medicaid, which pays a lot more than Social Security sometimes. And then there's other things like expedited reinstatement and things. So lots of work incentives that can help you maximize your benefit. SSDI, on the other hand, is different. Generally speaking, the work incentives are better than SSI, but it's a bit of a tomato, so I can't completely say that because there is a difference here. First, you start with the trial work period. Your trial work period, and I'm going to wrap this up in probably 3 minutes so I can get to the questions and spend the less time on that. Your trial work period lasts for at least 9 months because they look at a rolling 60-month period. And once you hit 9 trial work months, your trial work period ends. Now, how do you earn a trial work month? You make more than a set amount of gross income. And so for this year, for instance, anytime you make more than $1,050, you've earned a trial work month. You've used up one of your trial work months. The example below, for instance, shows you how that rolling 60 period kind of works out and how months are going to drop off. And so your benefits can keep going. But the big thing with the trial work period trial work period is that any amount you make during this time, you still receive your full SSDI benefit. So you could make $1,100 and that's one trial work month, or you could make $10,000 and it's still just one trial work month. So if you're going to go for work and you want to use your trial work months, go hard. Really dive in and see if you can work, right? Explore those boundaries because it doesn't matter how much you make. It's still just 1 month that's being used up. After your trial work ends, you enter the extended period of eligibility. The EPE lasts for 36 months. During this time, if your countable earnings are below substantial gain activity, you will receive your full SSDI benefit. Right? Flashback to that example I gave of a person making $2,000 with a 50% subsidy. Well, $2,000 reduces it to $1,000. That's below substantial gain activity. They'd still get their full SSDI benefit. Right? And so if their SSDI benefit was $1,200, which is the average benefit in the nation, now they're making $3,200 in income instead of $1,200 in income. Right? So that's why I say generally SSDI benefits tend to be better is you can make quite a bit of money on the SSDI because there's no effect to your SSDI benefit, which typically is more than your SSI benefit to begin with. Now, if your countable incomes are above SGA, then your benefits are found to cease or stop. If your income drops below substantial gain activity within 3 months, benefits resume without a new application. Right? That's the good news. Now, if they don't, your benefits are ceasing, right? So this helps when you have situations where like sometimes 1 month rolls around and there's 3 paychecks in that month instead of 2. And so the income pops above SGA and then the following month it drops below it again. Right? Or if you're managing your income and such and you just make a mistake and you work a little bit too many hours, well, as long as next month you bring it under control or within the next couple months, you're fine. But if you do go above SGA, you get no benefit that month. Now, after the extended period of eligibility list, and this is the thing I hate most about these SSDI work benefits, and that's that after the EPE ends, if you earn substantial gainful activity, so if you have that same mistake of 3 paychecks in 1 month and you forgot, and you ended up getting more than SGA, well, now your benefits cease, and to get them turned on, you need a new application. Now, there is expedited reinstatement, that you get paid immediately once you file that new application for up to 6 months, but it's only up to 6 months. And as I said, applications are taking around an average of 12 months, and you still have to go through the application process again. So that's the worst part about SSDI is you have to manage that income a little bit more to make sure that you don't suddenly lose your benefits sometimes. But you could also fully explore your work during this time period. So it's great if you really want to try to work. You can get more money, more benefits, but it's not 100% better than SSI. There are also other work incentives when we're talking about that countable income. Again, we have subsidies and special conditions, impairment-related work expenses, unsuccessful work attempts, past plans, continuing payments under VR, all these kinds of things, which is great. So brings your countable income below that substantial gain for activity. And that applies during the EPE and after the extended period of extended period of eligibility. Can't believe I forgot that last word. So great work incentives for SSDI. Questions. I have example questions on this next slide in case you don't, but I know I have to catch up on a lot of these questions. So here we go. You need to submit an additional document like a letter explaining why your son is not functional like other non-autism toddlers. I heard a letter helps. Yeah, a letter can help. Absolutely. Opinion letters are great. I recommend getting those, preferably from a professional, so someone more objective. That's what I first go to. And in that category, I like to look at doctors or treatment providers, teachers, educators, which could include administrators, that's fine, and employers, which obviously I'm hoping your toddler is not employed. And you might not have teachers, but maybe you have daycare workers or something, right? So opinion letters, the less connected they are to the child, the better. That's more objective, generally speaking. Okay, that's just an answer to someone else's question. That question, Byron, when you provide this number in July, on a different summer or September, call back. Great. I'm glad for that, Jen. Yes. DDS tends to be much better at responding to Social Security, so very happy for that. What is it called again? Mental blank. What is it? And that's the problem of having questions that I don't. Mental status exam. Mental status exam. Yes, Jen. I think that's, yep, an MSE, a mental status exam. That's what you need. Who can one get help from for their specific case? I'm a social worker who has done this for adults for years, but I'm overwhelmed figuring out for my kid. It depends on what county you're in, Rebecca, but our organization helps with cases. Big caveat to that is we're hiring a replacement advocate after our advocate who was in California finally passed social work school and decided to get a job in her field. I don't know why she did that. It was a mistake. I kid, of course, but we are in the process of that. And because we only have a half-time advocate, generally speaking, working on it currently, we've paused our referrals while we catch up to our wait list, hoping to catch up and start taking new referrals in November. So we can certainly help anyone throughout the state, regardless of whether they're attached to a contract or not. We're going to have a specific grant that's going to help us even more, especially for individuals who are not native English speakers. But that's not happening until later. We also have contracts that might be able to help the individual advocates dedicated to those contracts, and so they don't have a wait list like our general advocacy program, and they can serve people for free. And depending upon what county the person's in, if you contact us, we can tell you what's available, right? Because it differs by county by county. Some have a Center for Independent Living that might be able to help. Some have like Benefits in Action that's in Lakewood can help. They charge a fee agreement, for instance, like us. Bad Enterprises has certain grants and contracts that they can help on. It depends on where you're at, right? Vineland without intellectual disability, yes. Yep, Vineland or a adaptive behavioral assessment in general. Where can I see a list of all the documents SSDI requires? I have scheduled a phone call November 8th and want to be prepared to ensure I don't miss anything. For SSDI, what you would want is, and if you want to write this down, that's great. You need the Adult Disability Report, which is your SSA 3368 form. You need the SSA 827 form, which is your release of information to the Social Security Administration. You need the SSA 16 form, which is your application for SSDI benefits. They're going to do all of that over the phone with you, mind you. But if you want to take notes and look at them in advance, that's what you can do. Or you could go online and do it. And then it might make your appointment even quicker to do. And then there's other forms later on that you'll need, like a function report, history report, etc. But I can't list everything out, unfortunately. Sorry. Andrea, I only recently learned that my child's condition is probably eligible for SSI. He turns 18 next year, but he's had his diagnosis of birth. Any retroactive once I apply? No. There's two different situations we're talking about here. So he's under the age of 18 currently. If he currently qualifies for SSI, there's no look back prior to the application. That said, your application is going to take, say, up to a year, and they will back pay up to the eligibility date, which is the first day of the next full month for SSI. So in that sense, there is retroactive pay back to the date of eligibility, but not prior to your application. Likewise, after he turns 18, if he's applying for SSI, SSI is the same. There's still no look back prior to the application. If it's SSDI at age 18, there's no look back because SSDI eligibility begins at age 18. But if, let's say, he applied at age 19 instead of 18, but he was SSDI eligible as of 18, they could pay up to a year prior to the application, in addition to whatever back pay from the time it takes for the application to be decided. There's also a 5-month waiting period to make things even more complicated. Oh, let's see. Sorry, it's a direct message, so I'm trying not to read everything. Just treat the son as a household one. Yes, treat him as, well, in terms of rent, that's where your question's going. Thank you. You probably could do 2 rental agreements and just split them because he's only spending half the time in each. Yeah, and that would make sense. Or just if there's a primary residence, just having the rental agreement there. That's what most of the people I work with do. It's just one primary residence, and that's where the rental agreement is going, and they're not splitting rent between 2. So that's one position that will be paid as of next year. When interest grade 11. Okay. Could this impact him badly later? Probably not. Is it a bad idea for him to receive? No, I don't. I think that would be great, Nicola. Or Nicola. Not sure how you pronounce it. Nicola. Anyway, tomato. We're talking about $150 a week. That's $600 a month, approximately. Well underneath substantial gainful activity. I think that's great. And I strongly encourage employment for individuals who are transition age youth, children, young adults, because there's more opportunities. And you can establish a lot of things for that employment. If that employer knows, you know that going in advance, see what accommodations they're going to provide them, if they can provide them any accommodations. See if they can document that kind of stuff in particular. If they're going to know if it's being shared that he has a condition and they know it, they can document things that they accommodate for him. They can write opinion letters regarding his limitations at that job, whether 10 hours is about his maximum, if he calls in sick a lot, what kind of struggles he has. That can be great evidence and documentation for proving disability later. So I think that's wonderful. If your adult child is on a DD or SLS waiver before the age of 22, do you still have to prove disability? Yes, you do. Great question. And I think that might actually be in our common questions. Social Security, as I said, unique definition of disability. And by that, their view, which snobbish or not, take it how you live it. It's not technically arrogant, I don't think, but I can see the argument for it. They will consider, which basically means they're not really going to consider it. But they say they'll consider other findings of disability by other agencies. But those decisions do not control what Social Security decides. Now, what they mean by they'll consider is they will consider the evidence that agency relied upon to find someone disabled. They're not actually going to rely on the decision that the agency reached in finding someone disabled. There are some things that decision can influence. The DD and SLS waiver don't really help any with this, but like a vet who's 100% permanent total service connected disability, they can get their case expedited. So it does sometimes help. I would certainly submit evidence of that approval to Social Security. It might help because Social Security will request those records, and they might see some of the things that the agency relied upon in finding someone disabled under that waiver, but it probably won't help as much as you would think it would, or as much as it really should, probably. And to be fair, though, I've seen some of the stuff that goes into the DDS and SOS waiver. And I've also worked for Social Security, so I kind of understand why they don't just say, oh yeah, you're disabled. It's got to be a little bit more nuanced, unfortunately. How would someone document an unsuccessful attempt at SGA? So biggest thing is, why did the unsuccessful attempt occur? It's got to be due to the condition. So documenting that, whether that is through explaining what happened, or even better, getting something written from the employer. That would be the best way of documenting it. Income-wise, Social Security does share information or gets information from the IRS, so they can see some of that, but explaining what the income is, the best you can do, whether that's pay stubs or whatnot, is also good. But mostly it's going to come in the explanation, and whether you support that explanation with opinion letters or other documents from the employer, which is even better. Let's see, from Luke, and I think you're just answering that question. Looks like it. Okay, my 18-year-old was just approved for SSI. I'm recently divorced. My dad is interested to pay child support, and definitely will her SSI be reduced? Yes, it will. It would be reduced for the child support because that's unearned income for that individual. Now, that's not necessarily a bad thing, right? Because, I mean, there's only a $20 exclusion for SSI, but otherwise, if it's underneath basically 934, they'll still get some SSI. And they're not worse off for getting it. When dad or yourself retire or become disabled or die, they qualify for SSDI or DAC benefits. And so that child support will not reduce DAC benefits on the disabled adult child benefits. So, not a bad thing. Sometimes the consideration there is total income as well. And that's a Medicaid thing. Medicaid, you can make 3 times SSI in total income and still remain Medicaid eligible, but that would involve the individual that you're talking about actually working as well, Vicky. So that's a little bit of a tangent. If you didn't follow it, just forget I said anything. What about living caregivers? Has anyone in the chat ever had a problem with Medicaid or SSI in regards to being counted as regular income? If it's a child and there's parental deeming and mom and dad are getting money as living as caregivers under a waiver program, for instance, that income could be deemed to the child. If it is an adult, or then parents getting income doesn't affect child for SSI because there's no parental deeming. How does marriage affect SSDI? Whoop, I clicked back that accidentally, but you saw my origami bird. Oh, it even flies in reverse. That's awesome. All right. How does marriage affect SSDI for an individual who is a DAC? If that person who is receiving disabled adult child benefits marries, if they're marrying someone else who is on disabled adult child benefit, there's no effect. I believe if they're marrying someone who's on SSI, I'd have to verify this. I can't remember it off the top of my head. It also might not have any effect on disabled adult child benefits. However, if they're marrying someone who's not on, definitely if they're marrying someone who's not on SSI or DAC benefits, possibly if they're marrying someone who's not on DAC benefits by itself. And, as I said, I have to check on the SSI part. The DAC benefits end. They stop. The idea behind that, the policy, and this might help you understand why, which agree with or disagree with as you want. DAC benefits are the idea that this person has a disability before 22, they're reliant on the parent and the parent's income. So when a parent retires, they're losing income, but they still have this need to pay for and care for their child. And so Social Security is going to give extra benefit to help make up for that lost income. That same individual who's receiving DAC benefits, they get married. Well, they're not relying on their parents anymore. They're relying on their spouse. That's the idea. So now DAC benefits aren't needed because the spouse is going to take care of the other spouse. As I said, agree or disagree with the policy idea, but that's the idea behind it. Do SSDI, and there are exceptions, actually, rules where technically that ends DAC under one parent. If that marriage later ended, and that child could qualify off of the other parent, they can file again for disabled adult child benefits off the other parent. That's a unique situation of DAC, very uncommon, as you can imagine, but it theoretically could happen. But they would lose qualification for the one parent whose benefit was interrupted by the marriage. Do SSDI work compensation limits apply for a person getting the parent's Social Security benefit? Yes. Yep. It's still the same, treated just like SSDI stuff. Yep. Hope to start taking new folks in the event. Yep. Thank you. Yes, we will post. Yep. I was told rental agreements mean I would be a landlord by the state and subjected to regulations of a landlord. Is this inadvisable? I've not heard that, Julie. But it does make sense that you would be a landlord. That said, I'm not sure that there's necessarily a huge risk in that, because the question I would have is more practical, and that's going to be who's going to complain about the landlord. I mean, first and foremost, are you going to provide a livable space? Probably, right? You're probably not flying a flea bag kind of slumlord situation, but it's the disabled individual that would be complaining, or someone on their behalf, which would probably be another family member. So I don't know that that's necessarily a huge issue. I could see it causing in some uncommon, rare situations an issue where you might have to provide some sort of accommodation maybe to the disabled individual. Still kind of unlikely. And I know there are tricks to actually really taking advantage of being a landlord. So I've known people that have bought another home. Person gets a Medicaid waiver, then that individual or gets a housing voucher. Whether they're waiting for 3 years or not, they get a housing voucher. Person then becomes a HUD. Gets their other home that they bought as a HUD approved property, rents it to their child, and then gets rent payments for that. So that I've seen people do things like that, which can be very helpful. So generally I would say it's good. It's okay to be a landlord, but unique situations apply. And I am not in any way an expert in landlord tenant law. So I haven't heard it being a problem. Other parents might fill you in differently, or consult with an attorney who knows landlord tenant law. Marriage for marriage, we call this a marriage penalty. Yeah, I could. Trying to write down all my notes. Will this video be available? Yes, it will. I'm almost caught up on questions, but I'm still not. Oh my God, I've hit my 7:30 limit. Oh, good God. So if you guys want to keep hanging on, I'm still going to be answering these questions. If you have to leave because it's 7:30, I get it. We all have lives. But I will keep going away here at least for a little bit longer, for sure. Husband is unemployed and they could be recorded for the video recording later if you want to check it out on YouTube. Husband is unemployed and received an SSDI of about $800 a month. 6-year-old is mosaic Down syndrome and a Social Security number class, and requires constant monitoring for safety and hygiene, which is spelled out in our IEP. Would it be better to attempt to apply for SSI for her or to apply for DAC? Both would be what you'd apply for. So first and foremost, she should be receiving a portion of your husband's benefit right now because she's under the age of 18. And there's no disability application required for that. Okay. It is unearned income. So that might affect whether she qualifies for SSI as a child, because there might also be your income affecting that qualification. But she should be receiving money underneath your husband already. If she's not, it's because Social Security didn't take that application when they were supposed to, which happens, unfortunately, that they make a mistake, or someone answers a question not incorrectly because they don't understand what Social Security is asking. So I would follow up first and foremost with Social Security on that. Doesn't require an application for disability, just requires, hey, an application for childhood benefits, very quick and easy. In terms of when she turns 18, filing for SSI and disabled adult child benefits would be the path forward. When you file for SSI, you have to file for any benefit available. Disabled adult child benefits are available. She has to file for it. She can't turn it down. She could file for just disabled adult child benefits and not file for SSI. You can turn down the anti-poverty program because it's a program of last resort, but there's no reason to do that, right? She can get both benefits then, and they'll combine to be a higher amount. If you have to leave, okay, great. Luke, marriage penalty does not impact both adults on SSI, lowers limits. Okay, great. Almost caught up on the questions. Thank you so much. You're welcome. From Luke, rental agreements, leases to make you a landlord. So things like lead paint, lead paint discourses, CO2 monitors are needed. Yeah. Rent paid to you is considered income for you to pay us. And I've heard, in terms of the income aspect, I've heard both actually, because I've heard you can charge room and board. And if room and board is based on a shared expense. So we're talking about the shared rental agreements. If it's room and board, it's not income. And if it's not income, it's not taxable. I've heard that. I've seen that online. I am not a tax attorney, so I cannot verify that. It does make sense, though. For instance, if I'm living with 3 other roommates and we're all pooling our money to pay landlord, it doesn't matter who's writing the check in the end. That person's not getting income from us pooling money. So take that for what you will. You might want to check with a tax accountant or another attorney just to see. But the rent paid to you might, if it's a shared household, might not be considered income, is what I've seen from other discussions or discourses in the past. If it is rent, and probably a separate, if there's an income on it aspect, then yeah, it would be rent income and potentially taxable. Still probably worth it. And there's other benefits to charging rent than simply qualifying for SSI. Let me be clear on that, because what I've seen, for instance, not only can it maximize SSI, but it puts money in your hands instead of the child's. If the child's working, for instance, able accounts exist and they're great. Thank God for them. Able accounts for some individuals can be fully stocked up because of the income of the individual plus the benefit, especially if we're talking about like disabled adult child benefits. So let's say someone's getting $1,500 to $2,000 a month in those benefits, and maybe they're working on top of that. That $17,000 limit of deposits can be hit quickly, and you might still need to stay below at Medicaid's limits of $2,000 asset resource. So what do? Especially if you're not working. If you're working, you get Medicaid buy-in. But if you're not working, you pay rent, right? That helps get rid of some of your money. Mom and dad take rent, and what do? They can put it back in. Well, they can't necessarily put it back into an able account if it's full, but you can put that towards a supplemental trust or special needs trust. Or I've seen as a nice inventive thing, you buy a whole life insurance plan, which can be expensive, but it lasts your whole life. And you designate as the beneficiary of that whole life insurance plan a supplemental or special needs trust. And so now you've taken a little bit of rental income and you've turned it into hundreds of thousands of dollars that will later benefit your disabled child. Right. So there's lots of things you can do with that rental income that doesn't have to be for you, that can still benefit the child. If they're on SSI, Social Security only cares about food and shelter. You can buy them presents. You can purchase things for them. You can buy them health insurances besides Medicaid, all kinds of things that are not food or shelter and will not affect supplemental security income. All right, common questions. I don't know if you want me to answer these. We are over our time. Let me see if there's any really important ones. Families know about avoiding money withheld unnecessary. I think we're good with that one. Why do you have to document the news? We kind of covered basically that. Waiver programs don't mean automatic qualifications for SSI. Some of the common pitfalls avoided for applying for SSI. First and foremost, know how you can apply. Know non-medical requirements. Know that charging rent can maximize the SSI benefit. And documentation, as I mentioned, with medical stuff. That's huge for avoiding a common pitfall. What can SSI money be spent on? Food. And so, I tied this to another question of representative payees, because that's typically where these questions go with representative payees. If you are a representative payee, you have 3 obligations. First and foremost, to pay for the personal needs of the individual. That includes food, shelter, and medical care. You got to cover that first obligation. Second obligation, save some of the money for a rainy day, right? You have to have some general savings. Social Security mentions things like certificates of deposit, which are probably not a good idea to mention because that's an asset still, and you can get in trouble of getting over $2,000 following that game if you don't understand it. But you need to save some money. If you have an able account, that's a great spot to save it. And then third, spending the money on the individual on things that will benefit them. This is a very broad category, right? That can include things like entertainment. Kid wants to go see the movies. Sure, they can buy a movie ticket with that because it's something that benefits them, right? It's providing them enjoyment. It could also include things like they get really sore backs and you want to buy them a back massager, or they need a special mattress maybe, or they need a modification to their tub so that it can have a door that opens up. All kinds of things you can spend the money on. What you do if the bank account is approaching the $2,000 asset limit. If you have an ABLE account, transfer money to the ABLE account. If you have an ABLE account and it's close and it's at its limit of deposits, or you don't have one, you can spend the money down, or you can take steps so it doesn't get to that point, like charging rent. Even people on SSDI benefits can pay rent. It might not be needed because of a reduction in, there's no in-kind support and maintenance if you're on disabled adult child benefits or DAC benefits, but it still might help them keep that asset resource limit down for things like Medicaid. So lots of little things you can do. Spending down tends to be, in my mind, the last resort, because you might end up wasting money that way, buying things you don't necessarily need. But it's an option. And there sometimes are things that you could use, like a new mattress, that are expensive. And then we have one more question that came in through chat, and I think we'll be finished. And I'm going to move over to my contact information slide. We get to see our little origami bird one more time. My 18-year-old gets child support. If I charge her room and board, will this increase her SSI? Well, yes. Yes. There's two things that currently should be reducing her SSI. I can't say for sure, but if they aren't, then it might get corrected later on and be applied. So I'm just going to say they are, because that's what should happen. One thing that's reducing her SSI is child support. You can't really do much about that. That's happening, right? That's unearned income. It's great to get it. So it's there. The second thing that should be reducing her SSI is in-kind support and maintenance. And in-kind support and maintenance is a situation where you're not charging her room and board. She's not paying her fair share of food and shelter. And so by her paying her fair share of food and shelter, that would increase her SSI benefit. So that would be, that would be the value of charging room and board in that situation. It should increase her supplemental security income. You can do other things, like if you wanted to work, creating a past plan and things. Past plans can actually get rid of some of that child support effect on SSI, but those are complicated and I can't explain them to you in the next 10 seconds. One more question came in. When an adult is working, they have a higher yearly deposit limit for ABLE accounts and unemployment. I believe that's correct. If an adult is working, I'm not sure if that's correct. Let me rephrase that. So if an adult is working, they have a higher yearly deposit limit for ABLE accounts, so another employment benefit. And it's not a question. Yeah, I wasn't sure. And I say that because the ABLE account increase in deposits, I believe, has to be from the disabled individual. So when you say if an adult is working, if you mean the adult disabled individual, then absolutely I agree. It's got to be the disabled individual, from my understanding, that increases the deposit amount for an ABLE account. If you're talking about a child, I don't know. If it's a child ABLE account, you would know better than I do. I saw it was a direct message, so I didn't mention your name. And also, no one else saw your comment. So if you want to re-put that comment in there as not a direct message, then other people can see it. But otherwise, I read what you said. So yeah. Do you have a great website for Work Without Worry Act? I do not, although I've heard about it. And I believe I've heard about it. I believe that hasn't been passed yet. Or I'm getting that confused with one that has been passed. Yes, it's under review. That's what I thought. Okay. So I don't have a great website for it yet. From what I understand, there's still changes that could be made to that. I think that there should be changes made to that, to be honest. Just because I think it could be better, but it's much better than what we have right now. So absolutely great. Yeah. All right. Well, thank you, everyone. That is my time and more. It's 7:50 now. I went over 20 minutes. I apologize if you stuck around with me and you've just been slowly gouging out your eyes listening to me drone on. But I hope this has been helpful and useful. And I very much appreciate the opportunity to speak with you about these benefits. If you have questions, you have my contact information. Email is best. Big caveat to this is next week I'm gone for 3 days at a conference out of state for SOAR. which is a process that we use for applying for disability benefits, and I'm the state lead for it. And right after I get back, almost the following week, I'm gone for 2 weeks on a mini sabbatical. So if you email me in the next 3 weeks, it might be difficult to reach me. Right? I'm not going to check any email while I'm on sabbatical. I will be checking email next week. But I will also have someone covering for me, so they might email me if you mail in the next 3 weeks for information. Otherwise, thank you very much.
Thank
And
you.
hope everyone has a wonderful Halloween.
That was fantastic. It's I think a lot of folks are now empowered in new ways. So thank you.
My pleasure.
Thanks all for sticking around.
All right. Thank you, everyone.
Thank
I am
you.
going to go find dinner. Bye.